right. Well, it is 6:01 p.m. There is a quorum of the Ad Hoc By-law Committee in the room, and so I am calling to order the March 16, 2022 meeting of the Ad Hoc By-law Committee. Tonight's session is a public information session about changes to chapters 3 and 4 or the proposed changes to chapters 3 and 4 of the town's general bylaws. And we'll go through each of those chapters. Chapter 3 is financial matters, and chapter 4 is, if I remember correctly, legal matters.
And you're going to do another kind of Zoom on that.
That's right. So let us begin by sharing that. Okay, it's showing the right thing. Before we get into the review, no, I don't need to talk a lot about it. I'll hit it very quickly. Chapter 1 is general provisions with really generic stuff. Chapter 2 is general government, which is the core structure of how we do business as a town. Chapter 3 is financial affairs, how we deal with money. Chapter 4 is legal affairs, how we deal with the Office of Town Council and how we deal with certain other matters. Chapter 5, I'm sorry, I'm having trouble running. There it is. Multi-member bodies, which is to say boards, commissions, committees, councils, all of those live there. Chapter 6, which we will, 5 and 6 we won't be tonight, but 6 is public and private ways. How we deal with roads, fundamentally. And chapter 7 are the bylaws that, with a small asterisk, are not being modified at this town meeting. We'll talk more about that in the next session. The next session, by the way, is scheduled for April 6th, I believe. So please join us for that. We'll go over chapters 5, 6, and 7 at that meeting. So let us begin with financial affairs. So this is a half new bylaw. Philosophically, the Ad Hoc By-law Committee decided that bylaws should be centered on specific government either offices, single offices, or boards. In this case, the old bylaw was accounting and collecting, and it had duties for the town accountant and duties for the town treasurer collector. And now that we have people in each of those, we felt it best to split that one bylaw into two bylaws. All the accountant-specific pieces goes into the accountant bylaw that we'll do next. All the treasurer-collector pieces go into this, and we've also made some other changes we will be discussing soon. For those who haven't seen it before, we try to have a consistent flow to our bylaws, where Section 1 is always a purpose, which just describes what this bylaw is about. Section 2 is an authority, and there can be two different things, but the first part of authority is saying what part of Mass General Laws allows the town to write this bylaw. We generally call that an enabling statute. So we're answering the question, what is the enabling statute? When the bylaw has enforcement provisions for it, there's frequently a second part of Section 2 that says who the enforcing authority is. Moving on. So for offices, we will always have a duties section. There's one for the select board, there's one for the town administrator. And so for the treasurer collector, much of this, I should say, the first, I think, 4 sections are in the current bylaw. Yes, we've changed words. Yes, we've organized it a little differently. But treasurer collector fundamentally, number 1, collects all accounts due to the town for taxes, water and sewer fees, applicable interest, penalties, legal fees, and demands. So the treasurer collector does not collect everything that comes into the town. I use as an example the dog license fees. The dog tag fees are collected by the town clerk, and other fees are collected by other bodies as necessary. Planning board fees are collected by the planning board, another good example. So that's why the collections are limited to these three pieces. When the treasurer collector collects the monies, the treasurer collector is responsible for depositing all the monies into the town treasury. That means into a bank account. C is a new one that we added. I forgot we had stuck that in the middle of things. If there are funds that are not being used for something, the treasurer collector is allowed to invest those funds to earn more money for the town, usually through interest, but occasionally it depends on the investment fund. D, a new one also. I guess we only A and B was stuck around from the old. Treasurer collector shall manage long and short-term borrowing subject to approval by the select board. Why is the select board required? Because in long and short-term borrowing are contracts, and the select board are the only people who can sign contracts. More new. The treasurer collector shall administer the town's payroll. Now, I think that's straightforward, because all the employees like to get paid. The treasurer collector is responsible for that. Likewise, the treasurer collector shall manage employee benefits packages and employee enrollment therein. So she's responsible for making sure that we have a package, that we have packages that the employees know about, and the employees who wish to be enrolled, who are eligible, are enrolled. So that's a quick rundown of the duties of the treasurer collector. So as I said, other people collect money on behalf of the town. So every town official shall turn over all monies received on behalf of the town, except for those provided by law, to the treasurer collector at least once each week. And whoever that official is who's turning it over to the treasurer collector also needs to notify the town accountant of what was received in the accounts they're going into. So both the treasurer collector, who holds the money, and the accountant, who performs the audit, knows where all the money goes. The rest of this was put into a couple town meetings ago. This is what gives the treasurer collector the authority to not force someone who's been on tax title for a very long time to have to pay absolutely every penny of that. The details of it are in the bylaw. Basically, you have to owe more than $5,000. You have to be ready and willing and able to pay 25% up front. The term of that payback is based upon the amount of the amount of taxes in arrears. So less than $5,000 or up to $5,000. Yeah, less than $5,000. There's no agreement from between $5,000 and just below $10,000. It's 3. They can have a 3-year term, and above $10,000, it's a 5-year term. No exception, no anything different. This is exactly the way that the treasurer collector wanted it to be. And it's also possible for the treasurer collector to waive 15% of the accrued interest, not the amount of the money that's owed, but the interest that should have been collected on that. During the term of the agreement, the treasurer shall not bring an action to foreclose unless payments aren't made according to the schedule, or there are other taxes, fees, whatever, that the landowner owes and has not paid. There. That's treasurer collector. Norm or Anita, would you care to comment? Nope.
All good.
Okay. Then we'll move ahead to the accountant bylaw. As I said, this is the vast majority of this came from the old accounting and collecting bylaw, but it was just separated out so that we can document the office of the town accountant. What I didn't say earlier that I probably should have is we the Ad Hoc By-law Committee, believe that this separation and much of the work that we're doing around general town government will be highly applicable to the town charter when that effort is kicked off. So the town accountant, purpose, yep, duties and responsibilities, authority, we're given authority to write this bylaw by Mass General Laws, Chapter 40, Section 21. It's not specifically called duties because we have duties truly throughout this. We don't have a single duty section in this bylaw. But one specific duty is auditing the accounts, which is required by Mass General Law. And so the town accountant shall ensure that an audit shall be performed and it will be compliant with whatever the Department of Revenue says, however they say it needs to be done, whether process, forms, whatever. We don't need to specify that in the bylaw. We'll let the Department of Revenue make those determinations and changes as they see fit. So Section 4 is not a duty of the accountant, it's a duty of everybody else, which is anybody who has any bills outstanding has to get that information to the accountant before June 20th. Now the fiscal year ends June 30th, so the accountant has 10 days, to reconcile everything and to make sure everything is set up to close the books on the fiscal year. A question that's come up more than once is 10 days enough time? The accountant read this and didn't have a problem with this provision. So the town accountant, being the accountant, will define however accounting is to be done, including forms, tracking, and how it fits into auditing, receipts, disbursements, all of that. The town accountant defines all that for the town. So the town accountant job is purely accountant. I'm just going to differentiate that from the treasurer collector office, who's responsible for paying employees and managing the benefits packages and managing short and long-term debt. All of those are extra duties. There are no extra duties for the town accountant. Okay. Moving on. What's next is the Finance Committee. So if we have a chapter devoted to committees, why isn't the Finance Committee in that chapter instead of this Financial Matters chapter? This is one of those funny things where we just made our best guess of the most right place to put it. Finance Committee is number one, a special committee in a couple ways that we'll go over, but also has a great deal to do with the finances in the town and gets a great deal of information about finances of the town. So the committee felt that it was better to put the Finance Committee with financial matters rather than with the other multi-member boards, just like the select board is in general government and not in multi-member bodies. So, moving on. Yes, this is what the composition and duties of the Finance Committee. We are allowed to write this bylaw by General Laws, Chapter 39, Section 16. Here we go. Committee shall consist of 7 members appointed to staggered 3-year terms by the moderator at annual town meetings, subject to ratification by the select board. It's a fair amount of words. Let's break that down a little bit. 7 members. Great. That's pretty straightforward. Staggered 3-year terms. That means everybody's appointed to a 3-year term, small asterisk, and they're staggered so that you don't plan to have too many appointments every single year. The hope, like in most committees, is that someone who's appointed to 3 years serves 3 years. And if that's true for all 7 members, then most years we only have 2 members up for reappointment or for a new committee member. And 1 year out of that 3-year cycle, we have, no, I'm not doing math correctly, 7. So it's 3, 2, 2, that's right. So 2 of the 3 years, only 2 are up for renewal, and 1 year of the three members are up for renewal. There could be other vacancies. We'll talk about that when we get there. Though much of the subsections of A we added for clarification purposes. So, for example, we said, I'm sorry, I didn't finish all 4 parts of this sentence. I got through the number of members and the terms. The town moderator is, by law, the appointing authority for the finance committee. Every other full-born permanent committee is appointed by the select board, volunteer committee. So that's one of the things that makes them special. But also part of our bylaw has been subject to ratification by the select board. So the moderator at the very end of town meeting, one of the very last things he does before adjournment is naming members to the finance committee, whether they are reappointments or new appointments. And then it's up to the select board to ratify, to say, yes, we're okay with these changes. There's a philosophy that no single person should have appointing authority to as important a body as the finance committee. So whenever there's a single person, the moderator, making an appointment, other people have to agree that it's a good choice, that the appointments are good choices, or at least not bad choices. And so that's why the select board gets to ratify. One of our new sections, we explicitly say the select board's ratification vote by the select board shall take place no later than the select board's first meeting following committee appointments. So that'll say after town meeting. So they don't have to ratify at the town meeting. They're in session then usually, but that's not necessary. Failure for the select board to hold a ratification vote will be considered ratification. So if they don't take a vote at all, they're considered ratified. And any appointment rejected by the select board shall constitute a vacancy on the committee, which is dealt with later on. Norma or Anita, did we add to here? No town official or employee shall be eligible to serve on the committee. I don't remember if we added that or if that's already...
That's in there.
It is in there now. Oh, of course it is. I knew that.
Yeah.
Silly boy. Okay. So another thing that's different from most committees, their terms begin July 1, which is the start of the fiscal year. But appointment terms for the finance committee begin immediately upon qualification, which means when they are ratified or when the select board doesn't take a vote at their next meeting. And they begin from there, and expiring terms end at final adjournment of annual town meeting. So why could there be vacancies? Well, sometimes a seat doesn't get filled. We talked about one case already where the select board does not ratify a nomination or an appointment by the moderator. Oh, someone's joining us. I'm just going to wait a moment because I'll bet this person is still connecting to audio. But I'm just going to jabber on anyway. Oh, hey Jen, can you hear us?
I can. I'm just here to sit in.
That's fine. Nope, I just want to make sure that we've got good audio. Thank you very much.
Thank you.
So we are currently reviewing the Finance Committee, and we have just finished Section A, which is describing membership on the committee. So vacancies. How do vacancies come about? One is lack of ratification. One is someone could resign. They just don't have time any longer. There are a couple other ways we'll talk about, but any vacancy in general, subsection 1 there applies. Committee shall fill by majority vote any vacancy in its membership. So they get to fill it with anyone they want, and because because the whole committee's deciding, it's not a single person making the appointment. This is not subject, well, we'll talk about that in a second, but it's not subject to ratification by the select board, which is exactly the way that the current bylaw works. Yes, a record of the vote attested shall be copied to the town clerk. Sure. And as I just said out loud, these interim appointments that they're making, because these are merely interim appointments, need not be ratified by the select board. Then we have this whole thing, if too many people resign and there isn't a quorum, how do you fill the seats enough for the committee to meet? And the answer is the town moderator is responsible for that appointment. Obviously not during, or obviously, more than likely not during town meeting. Because resignations would happen earlier, or not at town meeting, some other time during the year. Yes, the moderator is still required to send all these appointments to the town clerk. And it does say right here, this is also subject to the same ratification as the appointments made during annual town meeting. So the board can get refilled by the moderator. If it needs to, it can fill vacant positions itself. Does it say the right thing? Yeah, that's the part that I skipped over. When the committee appoints someone to fill a vacancy, the term of that member, of the newly appointed member, expires at the end of annual town meeting. So that is potentially another slot that the moderator needs to fill at town meeting. Well, as I've said before, much of this, not all of it, but much of this is already in the bylaw. We just we structured it a little differently and hopefully made it clear and easy to understand now. I'm going to mention briefly the footnote that I didn't mention up above when talking about vacancies. These processes apply when someone is removed from the Finance Committee. There is a way up in Chapter 1, Article 2, all about appointed committees. There is a mechanism to remove members from committees. Without that, there's no way to do it. So we have a process to do it, and if a vacancy is created through that process, the appointment still follows the processes laid out here. So what does the Finance Committee do? Finance Committee works with the town administrator, department heads, and committee chairs to, and this is a controversial word, refine and amend the town's operating budget. In the town administrator bylaw, the town administrator creates the budget, the town's operating budget. And so there was we had originally put the verb create here, but that met with mixed reviews in the select board review. So we have proposed changing that word to refine. We have not heard from the Finance Committee if that's acceptable or not. So once the budget's done, committee shall discuss and report its recommendations of the budget to the town administrator. At the end of the day, the town administrator fundamentally owns the budget. That's part of the job of the town administrator by the bylaw. So anything that the Finance Committee does to the budget, any changes, have to be fed back to the town administrator. Committee shall submit the budget at annual town meeting. What that means is the Finance Committee shall make the motions related to the budget, to the town's operating budget. Nothing to do with the capital budget, that's a whole nother thing. And then These words are straight out of the original bylaw. We were a little afraid to change them for some fascinating legal reasons. Excuse me, I skipped over D. I'm good at skipping over things today. Committee shall discuss its recommendations on warrant articles received from the select board and report thereon to town meeting. That is to say, by law, and in fact by our bylaw, the select board is responsible for forwarding every single town meeting warrant to the finance committee for their recommendation. And the town moderator, if you've been to town meeting, knows that that after getting a motion and a second, that the finance committee is asked for its recommendation. So this codifies that process. Every article sent by the select board, they discuss it, they make a recommendation, then they report their recommendation to town meeting. Then E, everything that the town has an annual report. The finance committee is supposed to report its doings, what a great word, and any recommendations they feel are appropriate about town financial matters in their portion of the town report. A new one, which the Finance Committee pointed out is a good one to put in here, is the committee shall consider and may allow the transfer of monies from the reserve fund to a budgeted town account upon request from a town official. So, this doesn't apply to snow and ice, which is really special. That's really different. But let's just say the police department is going to overspend their overtime wages line item. Then one way to solve that problem is to transfer money from the reserve fund, which is a special bucket of money to deal with budgeting shortfalls. And the finance committee may allow it as long as there are two things in here that are important. Number one, the request has to come from a town official. It's not just anybody. No average citizen can suggest it. And also, it has to go into a budgeted town account. It's something was already created. So we can't just a Picon Conservation Commission wants to create a brand new account and get money from the reserve fund. That can't happen because there is no budgeted town account. So, Section 5 is not a duty or a responsibility of the Finance Committee. It's almost a power of the Finance Committee. The committee shall be given free access to books of record and accounts. So basically, if the Finance Committee asks for any information from any department, any committee, any town body, anything, the committee, whoever's been asked will respond and will give the information that's been asked. And right, so these two, A and B, kind of work together to make all of that true. Okay. If there are no questions, we'll move on. So, as I said before, there is a mechanism that applies to town committees that allow them, that enable the select board to remove members from that, to remove an individual member from any committee. But because this committee is special, it's appointed by the moderator, we thought the process is fundamentally correct as described, but what we wanted to say, so we say, follow the process as defined up earlier in the appointed committees bylaw, but The responsibilities ascribed to the appointing authority in the removal proceedings shall be performed by a joint body composed of the select board and the town moderator. So, if we had a fully staffed select board, there would be 5 members for that, plus 1 for the town moderator. That makes 6. So it's 6 people who together decide whether or not to remove someone, based on the process that there is. And I'm not going to go through that today. We've gone through that last time. And so the town moderator gets 1 vote, just like each select board member gets 1 vote. There is a possibility for a tie, but it is the Ad Hoc By-law Committee's opinion that if it ever came to that point, the odds of there being a tie are very low. And by the way, a tie means the member is not removed, because the motion is always to remove a member. And that is the end of Finance Committee. Moving on to the Capital Improvement Planning Committee, another special committee because of their involvement into financial matters of the town. That's another reason, again, this committee is in financial matters and not in other committees. I like the purpose. The entire purpose is to study proposed capital expenditures. What's a capital expenditure? It's anything that we purchase, whether it's a project or a piece of equipment that is, here I'll start at the bottom, total cost for the project or purchase price of at least $10,000. If it's less than $10,000, it's not capital. It has to have a useful life of at least 5 years and is purchased or the project is undertaken at intervals of not less than 5 years. So it's 5 years and $10,000 is the threshold. If you spend $15,000 every 3 years, that's not a capital purchase. These definitions for capital from our current bylaw, the Capital Improvement Committee has reviewed this, and I can't say emotionally they like it, but they understand. This is how it's been defined, and they didn't not say that they have a problem with it. Some more fuzzy terms. Committee shall be composed of 5 members who are neither employed by nor receive compensation from the town. So this is actually a little less restrictive than the Finance Committee. Nobody else with a direct connection to the town can be on the Finance Committee. They can't serve on any other committee, and they can't be employed by the town. They can't draw salary or compensation from the town. This is, as I said, less restrictive than Finance Committee in that you are allowed to have other committee members, members of other committees on CIPC, but they're not allowed to draw compensation, which actually lets out certain boards. Again, there have been a great deal of discussion about what the words employed by mean, because technically I, as Conservation Commission member, am an employee of the town, but I'm not employed by the town because I'm not drawing a salary. And our hope was that the words neither employed by nor receive compensation from are sufficiently clear to make the intent clear. Members shall be appointed to staggered 3-year terms, and the town administrator, town accountant, and treasurer collector shall be ex officio committee members without the right to vote. That is to say, they can sit on any meeting, they can take part in any discussion, but they can do everything except vote. Once again, we ask the question, what does the CIPC do? Again, everything is really all about creating and amending a capital expenditure budget. What money are we going to spend on capital each year? And they have to coordinate with the town administrator to make this happen because Sometimes the money's taken by loan. Sometimes it is acquired by getting a loan. Sometimes there's free cash involved. Sometimes there's some other way to get the money. The town administrator, being the chief financial officer of the town, is the coordination to determine where the money will come from for each item in the capital budget. So in order to create a budget, the committee needs to have input from the town, all the town departments, all the committees who might make capital expenditures, the regional school committees and other regional bodies. So there's BayPath and there's Wachusett, obviously, for the school committees, but there are other regional bodies as well. For example, our dispatch center is a regional service, and part of what they do comes from town funds, and part of what they do comes from other people. And anytime they do anything, a capital project, they need to go through the CIPC process. And all the B says is CIPC will tell everybody what the date is when they need to have their requests in. A late submission may not be accepted without extraordinary circumstances, which is explained down below. But oh my gosh, the water tower just broke down. We need to repair it now. It's still a capital project that CIPC needs to deal with. But committee shall consider the relative need, impact, timing, and cost of each anticipated capital expenditure and the effect each will have on the financial position of the town. What happens if we do the project or buy the thing? What happens if we don't? And how, again, goes back to working with the town administrator and how do we pay for it? So just like the select board has to give every single town meeting warrant article to the finance committee, they must give every no. I was going to say that wrong. It's not correct. That the select board is not allowed by our bylaw to place a capital expenditure on a town meeting warrant without the CIPC having at least reviewed it and considered it. This is not saying that the committee has to say, yes, we're going to do it, we agree with it, and this is how we're going to do it. That step is not necessary, but the CIPC must be made aware of it and have a chance to discuss it before it's placed on the warrant. And the last part is the CIPC reports to town meeting when the moderator requests for any capital expenditure. So not only does CIPC create the budget for the upcoming year, they also are supposed to have, and I believe do have, a 5-year plan for capital so that they can prioritize what's going to happen, not just next year, but the year beyond and the year. So 4 or 5 years that they will at least have a plan, and it'll be updated every single year, but they have a plan. So what is this extraordinary measures thing? I gave an example where we actually had pumps fail on a couple of our towers, and that was a big problem, and we needed to fix them right away. So it's considered extraordinary measure. Well, when something that is unplannable occurs, that you can still go to CIPC and request it and inform them of it, and they can do deliberation, but they only need to accept it as extraordinary measures if 2/3 of the committee agree that it's extraordinary. If 2/3 of the members don't agree, then it's not an extraordinary and it's not to be done out of cycle, which is to say anytime other than annual town meeting. But if the committee does affirm that it's an extraordinary circumstance, then after deliberation, the committee submits an addendum to their report to the select board. And none of this, no part of this whole section apply to citizen petitions. because citizen petitions must be placed on the warrant no matter what. So CIPC may not know about citizen petitions, and that's entirely okay, because that's the, I mean, it's permissible because that's the process. Finally, just like FinCom has to create reports, CIPC creates reports. That includes, number one, the capital budget for the next fiscal year, and the capital program, the longer-term 5-year capital program. All the reports that they make about individual recommendations or their budget, or actually the capital expenditure budget and any addenda, and the capital plan are all supposed to go to the select board, town administrator, and finance committee. Especially important if we're going to try to use free cash, because someone, again, it's up to the town administrator to balance all the free cash needs, but that's a lot. This is part of finance committee's space, and of course they include all their doings in the annual report.
There's still that little footnote 5.
Yeah, footnote 5 has completely disappeared.
Just in case somebody.
It's worse, yes.
noticed.
Footnote 5, which gives a statutory reference for the select board having to refer things, has disappeared for now. I'll worry about it more when we do a final publication. And footnotes are not part of the are not textual parts of the bylaw. They are editorial notations, just like all this history stuff that we have at the bottom. That's all editorial. It is not part of the bylaw proper. So it doesn't have to work correctly today.
Right.
One day, we hope, I can bend word to my will and make things appear. Revolving funds. So there are funds in town that are not generally or usually funded by the town's operating budget, but they exist because committees or departments collect fees, and they need those fees to pay costs. So each one of those uses will have a unique revolving fund. Sometimes more than one, because a fund, the use of a fund is pretty specific purposes. So, and we'll see that when we get down below. Some of 3 and 4 are new because the town accountant requested them. So basically, there's an amount set at town meeting that's allowed to be spent from the account every year. Annual town meeting is where we set that. This is just saying you're not allowed to exceed whatever was authorized either at annual town meeting or by change from the select board and finance committee. And B says quite plainly, well, not plainly at all, you're not allowed to spend more money than is in the account. Another accountant special, all general laws, bylaws, and regulations that govern the receipt, custody, expenditure, payment, and reporting of town funds shall apply to the use of revolving funds. So there are lots of laws about how, in the general laws, about how money is dealt with, how it's paid, how it's received. All this says is between this and all the sections, all the bylaws that we have before this, all need to be followed. There's nothing special about a revolving fund other than the amount that you can spend is fixed each year for it individually. The Ad Hoc By-law Committee had questions about how funds get terminated, so we felt it was a good idea to say explicitly a fund may be terminated by majority vote of town meeting. Somebody makes a motion to destroy it, which is, by the way, little more than changing this bylaw, and we'll talk about because this bylaw lists all the revolving funds. And when a fund is terminated, the balance of the fund after the fiscal year is over goes to the surplus general fund revenue. What are the funds? Well, we've got one for animal control. They receive money to deal with supplies for operation of the regional kennel whenever they need, to house or impound a dog. Board of Health has a fund to manage inspection services costs, all the expenses that they do with respect to inspections. The Earthworks Board, this is a brand new one, receives money when an application comes in and we need an account to put it in so that we can pay the costs. So the Earthworks Board can pay the funds, the costs associated with that permit, with that filing. Planning Board has one that looks just the same. They receive money for subdivisions and permits and I don't know all the goodies that come in, but whatever filing, whenever somebody has a filing, there's a fee. And it goes into the account. Recreation Department. So there are two here for the Recreation Department, and one is isolated to the Safe Place program. It's the way it was set up years ago. We didn't feel like digging in to find out if it has to be that way by state law. My guess is there is a law that requires segregation from other funds, which is why there's a special Safe Place one, and it's spent on salaries and school year programs. All the other fees that are collected by the Recreation Department go in this other fund. So for the pool or for the basketball program or whatever the programs are that they have, that's where that money goes. One final new account is for the Zoning Board of Appeals. They also have fees that are given to the town, and they have costs. Like the Earthworks Board, they need to put they need to post hearings in the newspaper, and that costs money. That money's got to come from somewhere. So the funding of this is being changed from pre-allocation of a fixed set of money in the general fund, which is the way it is this year. It will change to have a separate set aside set of money so that the fees can go in and they can spend out of that without having to worry about knowing how many permits they're going to have to deal with each year. And there we go. That's how we deal with money. Norm or Nita, do you have anything you want to add to any of this?
No.
Nope.
I think we're good. We've been over this and over this.
Mm-hmm. Mm-hmm.
Maybe to point out that all of these have had review by the appropriate boards, committees, and
That's a very good point. So the only one that is still open is that final one-word change in the Finance Committee bylaw. And so we're still waiting to hear back from Finance Committee. When the verb there was create, that had been approved. The Finance Committee voted and approved that bylaw amendment. So we're set for that. We just need that. So the accountant has seen the accountant one. The treasurer collector has seen hers and reviewed it. And we get feedback from everybody. Select board's seen them. And in fact, by now, the select board has already reviewed all of these bylaws that we're showing. Legal affairs. Okay, so legal affairs is a little wonky of a chapter. I think there ought to be something called legal affairs, but I still don't know exactly what we should have in there other than, let's do the very first one, which is the town council bylaw. So today there is a legal affairs bylaw that doesn't do a good job of describing what town council does for us. And so the Ad Hoc By-law Committee went off and did a survey and took from mostly Wellesley's bylaw, and then we modified the heck out of it because that's what we do, and really tailored it to this town. And the vast majority of the previous legal affairs bylaw has been moved into the select board bylaw because all the things we moved were duties of the select board. So, in order to make it best use of the select board, somebody wants to know what a select board does, they should have to go to one place, not to go to 13 different bylaws. That's our philosophy. So what is the office of town council? So town council is somebody who serves for 1 year from the first day of July until council successor is appointed and enters upon the performance. So basically, each year, the select board is responsible for appointing town council starting July 1, so, which is, as I said, the fiscal year. So hopefully they will have had that meeting before July 1. What does town council do? These are pretty broad because council fundamentally is, it doesn't say it, it's legal counsel. They are our attorneys. So whenever anything is involved with the law, town council is involved. So, council shall examine or cause to be examined all titles to property in which the town may be interested. That one I still think we should move later. I don't think it's a good leader. Fine. Council shall draw, supervise the drawing, or review all required deeds, obligations, contracts, bonds, leases, conveyances, agreements, and other legal instruments of whatever nature. Again, everything that has legal standing is run past town council. They are there to advise us, to tell us if there's a problem, a loophole, an issue, something more that needs to be mentioned in any legal document. So this is the counseling part. This is where we say, this is what we'd like to do, and they say, here's what it means to do this, here's what you haven't thought about. This is giving us counsel. Council shall commence and prosecute all legal proceedings by or on behalf of the town, any committee or official. So if the town is taking somebody to court, town council is our legal counsel and represents us in court. There's a bit more about some detail here. Nothing shall commence until the select board or town administrator has approved the proceeding unless that official or committee and council agree the situation to be of an emergency nature, or the committee or official is vested by statute or bylaw with authority to initiate legal proceedings. So if there's something in Mass General Law that says, I'm just going to pick on planning board, that planning board is allowed to sue someone directly to initiate a court proceeding, then they don't need, they don't need select board or town administrator approval. I don't know that that case is true. I just picked it out of the air. You could replace that with anybody. Actually, I could specifically talk about the treasurer collector because her ability to go to land court is not limited by the select board or the town administrator approving it.
That was a while ago.
Not here.
No.
Sorry. I don't know who's trying to get in, but they're not. I'm looking at it right here, and there's nobody in the waiting room.
There? Okay.
So I wonder if they went to our usual
Regular.
or the previous posting.
That's below the first one, though.
Okay.
But that could have happened if they had
Right.
pulled up trying the same Zoom, because we did have to change it for this
Right.
session. So if anyone's listening out there,
If you know of anybody who's trying to get in, make sure they have the correct Zoom meeting. Okay. Actually, let me Let me just check my email, which is a bad thing to do while I'm in a meeting, but oh my gosh. Nope, nothing new. Good.
Don't want to exclude anybody.
I have a whole lot of email today, but nothing about this. So, 4C is about the town suing someone. If someone sues the town, that's D. Council shall defend all actions of suits brought against the town in any court or other tribunal in the Commonwealth or elsewhere. So if the federal government decides to sue the town council is responsible for defending us. And it doesn't matter if it's the state, if it's by the feds, if it's by an international body, by some other country. I can't imagine why any other body would, why Russia, I'll just pick on Russia today, why Russia would want to sue the town of Rutland. But if they did, there is a court for that to take place, and our town council is responsible for defending.
Never can tell about Vladimir.
True enough. He could have his eye on Rutland right now. So there are proceedings that the town initiates. There are proceedings initiated against the town. And then there are other proceedings that the town may have an interest in. A lawsuit between the state and some other town, but could impact the town of Rutland. And in that case, the select board directs council to appear in that action on behalf of the town. F is also very important. So here it talks, D is defending against suits brought against the town when the town of Rutland is named as a defendant. But sometimes individuals, the DPW director, the chair of the Conservation Commission, whoever, could be named in the suit. This says that if the town official was acting within it says proper performance of any official action, and somebody doesn't like that action, they'll sue that town official. So long as the town official being sued was properly performing the action, didn't threaten someone, didn't break the law, and by enforcing a regulation or a law, and they get sued because of that, council defends that official. But proper performance of any official action or duty is very important. It doesn't mean that council defends every town official in every single action, because if the town official... How you doing? What's going on, Paul? Who are you looking for?
Looking for the budget meeting. I think it's in
Over
there.
there, correct.
Thank you.
You're welcome. If the town official broke the law, town council is not going to defend him. If the town official is brought up on, they're probably civil. I believe that the Ethics Commission only works with civil enforcement, not criminal enforcement. But even then, that is not within the realm of town council to defend. So this last one is sometimes we need someone to talk to the legislature or a committee of the legislature on more than likely a bill. In such a case, council appears before the legislature or that committee on behalf of the town. But either the select board needs to request it or town meeting has to request it. And that last one is very unlikely in terms of it getting all the way to town meeting to get them to do it. But it didn't seem like a bad out to have in the bylaw. And finally, town council shall review all town meeting articles and motions for form and legal sufficiency. There. So, the town currently has appointed KP Law, which is a fairly big firm, relatively sizable. They do many, many towns in the Commonwealth, but they don't always know everything. And I know it's hard to believe. So there is this notion in law of special counsel, which is to say someone other than our normal town council to either initiate or defend or manage. So if a committee believes that KP Law does not have, or town council generically does not have, sufficient experience in a specific area, that that going through the select board or the town administrator to get this approval, that a committee or the select board or the town administrator may use special counsel, employ someone other than our appointed town council. And much like before, when we said sometimes the only people who are supposed to start to initiate an action of the select board of the town council, unless there's a law, well, it's the same kind of thing, where if someone wants to use special counsel and there is something that enables them, that body or that official, to talk directly to special counsel, they're allowed to do that. But short of already having an explicit statute or bylaw that authorizes it, or a vote at town meeting, it requires approval of the select board or the town administrator. Which makes a lot of sense because council is always expensive, no matter who they are.
I was wondering if some official managed to get some other legal counsel to work pro bono.
It's still employing special counsel, because one of the definitions of the word employ is use. At least that's my feeling on how the select board and town administrator would feel about that. But in truth, hasn't been tested. We haven't thought that much about it, and I'll let town policy deal with that. Yep. Since I know I know for certain of one committee that is using special counsel today. Now, today there is no bylaw about special counsel, and I don't know of any policies, so I don't know how against the rules it is, but if this bylaw is adopted, it will become an issue. And that's it for town council. Now, the rest of the bylaws that are here are what we called punitive bylaws. It's just, every one of these is, you need permission to take an action. If you don't get permission, you get fined. So what are these? Well, the first one is, if you don't, well, this is actually a little different than what I just said, because this, if you don't pay your taxes, the gist of this bylaw is you're not allowed, if you don't pay your taxes, you're not allowed to get licenses and permits. You're not allowed to build a house or do any construction. You're not allowed to get a fishing license. You're not allowed to, there are a host of permits and some exceptions. So this bylaw gives the town the authority to not grant or to rescind licenses and permits. Now, this bylaw does not look quite like the others. We have a lot of formatting in common, but when we get into the meat of the bylaw, you'll see that there are many longer paragraphs, and that's because of a disagreement between myself and town council about what is required to be in this bylaw. This bylaw is enabled by MGL Chapter 40, Section 57. And that section of MGL says that the town bylaw must have the following provisions. What legal counsel seems to believe is that the bylaw must say exactly what it says in MGL. I disagree. I think that those words mean that we must every element, every requirement, every element in MGL is a requirement that must be within the bylaw somewhere, but it doesn't need to be expressed in the same way that MGL expresses it. So, we missed an underscores on town charge.
Oh, yeah.
I would also like to know what the delinquency party.
Oh, I guess I didn't fix delinquency party.
Boy.
I thought I had fixed that up. I guess not. Or it is updated, but I didn't include it when I made this PDF, which is my own darn fault. Again. And in fact, collector has too much underlined.
Oh, yeah.
So, where I would say treasurer collector throughout this bylaw, the MGL says the tax collector and uses tax collector instead of treasurer collector. So we have to use the term collector because it's the form of the current law of MGL and it's what we incorporate. And anybody who's late on taxes, fees, etc., and there's no application for abatement. Who the heck is the appellate tax board?
There is one.
There is one?
Oh, yes. State.
I don't think I knew that. Okay.
Yes, the assessors go to the appellate tax board.
Okay.
I'm not too sure beyond that I know the term, but they do use them.
Okay. Well, if there is one, so be it. Great. Then everything we're doing makes sense here. So, the licensing authority is anybody who can issue a license or a permit, which is actually defined in the general provisions bylaw. So what this says is the treasurer collector is supposed to, from time to time, send out a list of delinquent taxpayers so that licenses and permits won't be issued, or at least may not be issued. The vast majority of this bylaw is, other than form, exactly the same as what we have today. There are a few changes in A because we put definitions up high to make it easier to read what is today about 3 times longer. We also did do a little splitting of paragraphs and a little bit of reorganizing, but I hope town council won't have a problem. So, a licensing authority may deny, revoke, suspend any license, permit, certificate, approval, order, or similar authorization. And just skipping to the bottom, there may be a hearing before the licensing authority. But there doesn't have to be. I think that would be highly authority and permit specific. Because it could very well be that revocation of a permit requires a public hearing. But I don't know that. So, if somebody's name is on the list of delinquent parties, that by itself is enough to allow the licensing authority to not issue, or to revoke, or to suspend. So it is therefore up to the treasurer collector to make sure that list is up to date. and published as necessary. Treasurer Collector may intervene in any of these hearings or any proceeding. Basically, if I'll pick a Conservation Commission. If a Conservation Commission were going to say we are revoking your permit to do the work you have planned to do, and you have to stop it now, the Treasurer Collector can intercede. And it's only when a licensing authority does this. They do it only for one permit at a time. They don't do it for every single permit. So if someone has 14 building permits, each one has to be processed individually. At least that's my reading of this.
Mm-hmm.
I don't know what a certificate of good standing is. I don't know of such a thing, but I've never seen one. But maybe the Treasurer Collector has that. I can only presume that it's a document that says that the person can show, so that the licensing authority will know that the party's in good standing and is no longer on the list, but Treasurer Collector doesn't need to publish the new list right away. Now, none of this applies if the tax collector, the Treasurer Collector, and the delinquent party enter into a payment agreement and the payment agreement is being honored by the delinquent party. And finally, I take it back. It's not finally. It's almost finally. Select Board may waive any denial, suspension, or revocation. So if Conservation Commission takes action to deny, the Select Board can say, no, don't do that. So they are fundamentally the appeal process for any denial or revoked permit. So there are a bunch of permits you're not allowed to suspend, revoke, or deny because of lack of tax payment. The open burning permit, the bicycle permit that isn't applicable anymore, charitable purpose sales. Children work permits is really interesting. I'm not sure if that's from the worker side or for the company side, but et cetera, et cetera, et cetera. No, see, I mentioned fishing license before. That's actually an exception, so we're not allowed to stop that one anyway. Can't stop marriage licenses. If someone's going to put on a show, they're allowed to put on a show, et cetera, et cetera. And that's the end of that. Moving on. We currently have a bylaw called public drinking. At the request of the Chief of Police, we expanded this bylaw to include public consumption of, I'll just simplify it, marijuana. Yes, the definition is somewhere else. I'm not going to worry about that, but so you'll notice that there are two authorities. Actually, I want to start at A. Defines the penalties for consuming intoxicating substances. So we talk about we have the definition of consumption and intoxicating substance, so everybody knows what they are. So there isn't a lot of question as long as you're willing to look forward. So why are there two authorities? Because General Laws, Chapter 272, Section 59, is what allows us, the town, to regulate public drinking. But there is no direct equivalent for marijuana in the general laws, and so we go with Article 89 of the Massachusetts Constitution, which is what's called the Home Rule Amendment. The Home Rule Amendment basically lets us write almost any bylaw we want without needing permission from the legislature. There are things we have to do that still require legislative permission, but in general, bylaws of this nature are not one of those things. So, an intoxicating substance is any substance or product which causes or whose fumes are capable of causing intoxication. Such substances include, but are not limited to, alcohol, marijuana, and products containing THC. And consumption, again going back to the purpose and what does consuming mean, ingestion, inhalation, or any form of transfer of an intoxicating substance into the body. Some of this we came up with, but I don't remember where transfer of an intoxicating substance into the body came from. Anybody remember that? No. It's not that important.
No.
I mean, we obviously found it someplace. So,
We mean to include injection.
that's true.
Yeah.
So this is, as I said, this is one of the prohibitive bylaws. It's just don't do it. So in this case, consumption or possession of an open container of intoxicating substance. Most of this came out of the current public drinking bylaw. So where it used to say an open container of alcohol, it's now an open container of an intoxicating substance will be subject to fine as published in the schedule of fines and or arrest while within the area of a public way, if you're in a street or a sidewalk or a trail, within a private way open to the public. So it can be not a town road, but if it's open to the public, which is not very well defined anywhere, I'll admit that, but if it's in general use by the public and if the town always is clearing the snow so the town has permission to enter, then it's pretty much open to the public. In any public building, on any public property, and in any private way or parking area regulated. So if it's a parking lot, it's the same thing even though it's private. And upon any private property, so if somebody enters somebody else's land without permission, they're subject to the same problem. So this gives the town basically authority to enforce this on private land. I would presume the process would be that the owner of the land would call and say, this is happening on my land and I don't like it, please take care of it, which implicitly gives the town permission to enter the private property and to enforce the law there. And there are exceptions. So Section 4 does not apply to any activity licensed by the Select Board to allow consumption of intoxicating substances under applicable provisions of the general laws. So when we have the 4th of July and somebody selling beer, by virtue, that is a licensed activity on public property, which would otherwise be disallowed.
I'm assuming they cannot issue a one-day marijuana license.
I would not, I don't know of any provision that would allow it. This is written generically enough that if there is an enabling statute to have a one-day marijuana license, and they wanted to do it on the town common,
I'm just thinking of someday.
that's right. Someday it could happen. And if it's not licensed by the Select Board, it's enforced by the police department. And if it is licensed, it's allowed an exemption to this prohibition.
They should just run and breathe deeply.
Mm-hmm. Hope the wind isn't too strong that day. And that's it for this bylaw. The next prohibitive or prohibition kind of bylaw is unregistered motor vehicles. You're not allowed to have more than 2 unregistered motor vehicles, disassembled vehicles, or parts of vehicles on any single premises. The keeping of more than shall not be permitted unless stored within in the open. You're allowed to do whatever you want inside a building, but in the open, you can only have 2 car carcasses. Unless it's a farm vehicle, which is defined in Chapter 128. So farm vehicles, no enforcement. And I don't know that this bylaw has ever been enforced, but it's there today. We're just going to keep it. We haven't had any requests to remove it from the police department or anybody, so off we go. And is that it?
That's
that, my
it.
friends, is the end of Chapter 4. Jen, as our one guest, do you have any questions or comments?
Nope, nothing yet. Thank you.
Oh, just a second. Try again. The speaker turned off.
I said, no, I'm good for now. I'm still just taking it all in. Thank you.
Well, there's certainly a lot to take in. We understand that.
Thanks for listening.
Thank you for coming in. I will repeat something I said at the very beginning of the meeting. Chapters 5, 6, and 7 are scheduled for April 6th.
Okay.
Please tell your friends. Maybe we should offer donuts and coffee. Then we might have too many people in there. But, all right. Anita and Norm, closing thoughts?
You're thinking of closing.
Boring.
Maybe not the most exciting bylaws.
No, these are not.
but
I get it.
They're there, and
I don't think there's a lot of controversy in these. I mean, yeah, Finance Committee has their own little controversy about specific wording. I get that, but it's not, from a town-wide perspective, there isn't anything controversial here, I don't think. How we manage money, and how we manage town council should be well documented.
Mm-hmm.
Okay. Well then, I'll accept a motion.
Motion to adjourn.
second.
Roll call. Anderson.
Aye.
Carlson.
Aye.
Crane, aye. We're adjourned. Jen, thank you very much for showing up. We appreciate you being here and interacting with us a little bit.